My name is Janina Dill. I'm a professor of global security. Welcome to my exp. One thing that's important to understand is that when states are at war with each other or at war with non-state armed groups, they think of themselves as in an emergency, so in an extraordinary state of threat. And in that context, there's always going to be pressure on the normal rules of politics. There's always going to be pressure on law. So in a sense, the laws of war particularly are always in a type of crisis of compliance, because there's always an exceeding temptation not to stick to the rules. Yes, states have reasons, good reasons to stick to the rules, like they want the embrace of legitimacy that law can bestow, but it is always an uphill battle to demand compliance with the laws of war when states are at war. And even against that backdrop, right, of a sort of constant state of crisis for international law in war, we unfortunately have to say that the wars of Russia in Ukraine and the current military operations of Israel in Gaza are causing a sort of perfect storm for international law that in some sense makes that crisis much more dangerous. The overall number of death or injured or refugees that a particular military operation causes, like a particular war, isn't indicative of whether or not the party to the war is complying with international law. It's one important data point, right? So is the ratio of civilian to combatant death as to whether or not we should get worried about legal compliance. But ultimately, when we ask whether a party complies with international law, international humanitarian law, the laws of war, we must look attack by attack, because that is where the legal demand attaches to, right? Each attack must comply with the principles of distinction, necessity, and proportionality. And that is where we must focus not on the kind of overall casualty numbers. Patterns of attacks also matter, but again, as a first indication of whether we think a party to the war is displaying fidelity to law, to really make a determination of whether a particular attack or any particular conduct violates international law, we have to look at that attack in detail. And the law is really very fact-hungry here. We need a lot of information about a particular attack, for instance, attacks that look like they were directed against hospitals, to say, is this a violation of law? Is it potentially even a war crime? We read a lot of contextual information, and oftentimes we need to know what the attacker reasonably thought about that attack. And that's not always easy to infer from the context, which is why it is important to exercise caution. But there's also a point where we have to say that there's a reasonable grounds to believe that there were violations of international law, and those reasonable grounds to believe should be enough for third states to take action. When there's a pattern of attacks, each of which provides reasonable grounds to believe that it violated international law, then even if we cannot definitively say that it was a war crime, which is often what people want to determine in public discourse, even if that can really only ultimately be determined by a criminal court, the kind of obligation of third states to say, well, there's a pattern of attacks that look like they violate international law, that is at the point where those states should demand compliance, they should demand a change in tactics and strategies from the party that's waging war. There's an unfortunately quite common historical phenomenon where one group of people tries to destroy another group of people in the context of a war or simply as a kind of campaign of extermination. And that phenomenon, we call this genocide only when we can show that it follows the intent, so in some sense like a deliberate purpose of destroying the group in whole or in part. So if the extermination or the risk of extermination of a group, for instance, is a side effect of another purpose, it's just simply foreseen but not intended, then even kind of a campaign of violence that really objectively poses the risk of eradicating a group of people wouldn't necessarily be a genocide. So genocide as a legal category is quite narrowly conceived. There's quite a high threshold of evidence that we need to say that something poses the risk of potentially being a genocide. And that, of course, also carries the risk for us to kind of deny the charge, right? To say that we don't have enough evidence. And the Convention on the Prohibition of Genocide, in a sense, takes care of that by creating an obligation to prevent genocide. And the obligation to prevent genocide kicks in at the point where there's a risk, a serious risk, that genocide is committed. And I've argued that that risk should already, in some sense, be diagnosed when there's a risk to the destruction of a group in whole or in part, even if we can't be sure that this particular type of intent is there. And that's because that intent is systematically not visible to the naked eye. The most simple and straightforward thing that states right now can and should do is withdraw support from parties to a war that provide reasonable grounds to believe that they are not complying with international law. That is much more effective when you do that towards your allies and friends rather than towards your enemies. So Western states, particularly European states, the United States, had really initially no problem to sanction Russia, for instance, for violations of international law. And they haven't, by and large, been able to do the same with Israel. These same states had no problem to welcome the arrest warrant against President Putin, to welcome the case against Russia before the International Court of Justice. They have worked with and supported these bodies of law, and yet they have not been able to do the same in the case of the cases against Israel in front of the International Court of Justice, or indeed the International Criminal Court. So changing that pattern of inconsistency is the most straightforward political prescription that comes out of a systematic analysis of the crisis we currently face. And that would make a difference for the people on the ground, because wars can only be waged with weapons, and weapons embargoes can be quite effective in curbing violence. They also kind of send a message that a state cannot act with impunity, and so they can alter the political coalitions and discussions within a state. Within Israel, for instance, there are different factions in the government that have kind of different visions for how the war and the campaign in Gaza should unfold, and an international community that would be steadfastly in support of compliance with international law, and that would consistently, without fear or favor, sanction really systematic and severe violations of international law, would empower the voices in Israel that demand compliance from the government. It's more complicated in Russia in the sense that this is an autocracy, and it's really seemingly only President Putin that's making decisions about how the war is conducted. But the kind of hypocrisy and inconsistency in demanding compliance from very powerful states like the United States is one of the key problems. And remedying that would alleviate the suffering of people on the ground, because it's a complicated causal chain. But the reason for why people in Gaza don't have enough food, for why Ukrainians in the winter often don't have enough electricity to stay warm, these are also all kind of the ultimate outcomes of causal change that are triggered by the delivery of weapons that are then used in violation of international law. Law on its own is no silver bullet. It can neither prevent war nor can it make war somehow kind of morally acceptable. The prohibition on the use of force hasn't saved succeeding generations from the scourge of war as promised in the UN Charter, and even perfectly legally compliant warfare is still a moral catastrophe. So law is only one piece of the puzzle. There are other considerations that must be addressed, like the politics of conflict resolution, long-term historical memory and trauma. There's many other considerations that must come into play, both to prevent war and to limit those wars that we didn't manage to prevent. But ultimately, the problem with this is still political. It is still a problem of states actually standing up for the legal provisions that they themselves wrote and agreed on, right? So the problem with non-compliance with law and the problem with overly permissive interpretation of law is one of states holding each other to account.